Who are you? Who am I talking to right now?
My name's Paula. I'm the prosecutor.
Paula, do you have a last name, Paula?
Dixon?
Paula Dixon, okay.
Mm-hmm. And it looks like you're set for pre-trial today and oral argument on your motion. Let's see. You are being charged with consuming alcohol in public as a Class 2 misdemeanor. Will you explain the plea at all?
I don't know. Maybe. I think I might have.
Maybe? Okay. Well, it's a fine. It's $151.95 if you'd like to plead guilty and resolve your case.
So, my original question, I don't know if you've spoken with anybody about this, but I still haven't even entered a plea, so I technically can't even be doing this right now. I haven't been explained the nature of the cause of the charges against me. I've not entered a plea at all. Still.
No, you haven't entered a plea.
Correct.
This is a pre-trial, and this is where we talk about the plea. So the plea is to plead guilty to the charge and a fine, and pay a fine.
So, correct me if I'm wrong, but according to the rules of criminal
guilty,
procedure, pre-trial is supposed to come between arraignment and jury trial, correct?
Yeah.
So, if I have not been arraigned, I have not entered a plea yet. How are we doing a pre-trial conference right now?
Let me look. So you haven't been arraigned on this?
The judge tried to enter a plea for me, and I objected to it, and there's multiple motions against that. You know, like I said, I have not.
Let me take a look at something to see if you've been arraigned. 1899537. Yeah, you were arraigned on 7/19 of 2013.
Kind of interesting because, again, on record, I have not entered a plea, and there's objections to the judge entering a plea for me.
Okay.
I've not been informed of the nature of the cause of the charges against me.
Okay, well, we disagree with what you're saying. So do you want to plead guilty, or do you want to set it for trial?
Well,
Or would
I'd
you
like
like a
to.
continuance?
I'd like to, before I can do anything, fully understand the nature and cause of the charges against me.
Okay.
Again, I have not seen. I don't know if there's any evidence of jurisdiction, evidence the code applies to me, evidence of a victim, evidence
No,
of
there's no
damages.
victim. There's no victim.
Let me get this right. There's no victim.
No.
Is that correct?
That's correct. It's not a victim case. This is you consuming alcohol.
Okay, and this is a criminal charge. Is that correct?
It's a criminal charge. It's a Class 2 misdemeanor.
Criminal charge, and you were saying there's no victim.
No.
Okay.
Not
just
all
wanted to make
criminal charges have victims.
Just want to make sure I have that down.
Any other
So,
questions?
Yeah, there's many questions. I've put them all in motions.
Okay,
I
let's
still...
go see the court. I'll tell them you're here.
Okay. And actually, I have one other question, too.
Yes.
Have you actually spoken with the officer or read the discovery report yet?
I have not
Okay.
spoken to the officer.
Have you read the discovery report?
Let me see. I'll tell you that right now. No.
Okay, so
I
you're
have not.
bringing charges against me without...
Another prosecutor in our office has reviewed the case and made the offer.
Made the offer to prosecute me?
No, made your plea offer.
Okay.
But yeah, we are moving forward with prosecution.
Okay, that's interesting. All right, thank you. So what's next?
Just have a seat in the court.
Okay.
Well, did you want a continuance from today's date? Or do you want to set it for trial?
Well, again, there's at least 3 different motions I've filed that need
Okay.
to be ruled upon, and like I've said before, I
Okay.
don't believe I've even entered a plea.
All right, let's go in here. Okay. We're gonna have a seat in the courtroom.
Okay.
Okay.
Yes. Let me...
Have a seat at the legal room. CR 2015-0170. So I understand from reading the documents that you're not a lawyer, not law trained. Purpose of an oral argument is simply for you to speak on your behalf. I read through everything here, so the argument is just to present how you wish to enhance that written material in any way before you issue decisions. So you may proceed.
Okay, so first, well, I'm a little confused. Which is the judge on my case, because the documents from the prosecutor say one judge and the clerk told me another judge. So who am I talking to right now?
My name is Judge Bell. I'm what's called the Judge Pro Tem.
Okay.
The whole collage is normally in this courtroom. He's having medical procedures. So is this case assigned in the courtroom?
So, okay, so then it is correct that
Collage, OLCAGHE is the assigned judge.
okay, so then it is correct I spoke with James Blake on July 19th? Is that the one?
His initials are in the file, but he is not the assigned judge for it.
Okay. So to begin with, again, I believe I have not even entered a plea yet. On July 19th, Judge James Blake denied me my rights to know and understand the charges against me and continued to enter a plea against my objections while I was trying to understand and make a knowing and conscious plea. Again, I still have not been presented any facts so that I can know and understand the charges against me. I'd like to enter pleas once I understand the charges. And I'm waiting for that information. I have some questions, but again, on July 19th, Judge James Blake denied everything and entered a plea for me, representing me against my will.
Anything else?
Well, I've got lots of questions I'd like to answer before I can enter a plea. Specifically, there's two motions outlining reasons to strike or dismiss this matter,
That's what we're here for today.
and then also the motion for disqualifying Judge James Blake.
Yeah, not right now. That motion would be continued if at some point in the future Judge Blake is assigned to this case.
Okay, so to confirm, Judge James Blake is not assigned my case.
At this time, that's correct. So it's possible you can show him on the day of the trial, and if Judge Okolaj is sick, and Judge Blake is available, we'll say he'll pick up the board, we'll file over there.
Okay. So then I understand I've submitted two motions for striking and dismissing. The prosecution has submitted responses, and I've submitted a response to the prosecution's response. Do you have all of that? Okay. So I'd like, I guess, you can go through point by point why I think this should be dismissed, if you'd like.
Okay.
So to begin with, for this matter, I've not seen a valid charging instrument or complaint or verified ticket, whatever the proper term is. I've got the exact legal citations. If you give me a second. So I believe the court, on motion of the defendant, shall order that a prosecution be dismissed upon finding the indictment, information, or complaint is insufficient as a matter of law. So on my motion dated 7/19, I have 6 specific challenges to the sufficiency of the complaint. They are outlined in my response neatly, or you can go through the motion on July 19th. I don't see, is there facts on this motion by the prosecution showing facts that there's jurisdiction? Presented facts showing that the statute allegedly violated applies to the defendant in error. Presented facts showing there's an injured party, and presented facts showing there's loss or damage. Is that on this Arizona traffic ticket and complaint?
You're asking me a question when I'm here for a dialogue.
Oh, no, I am. That's specifically what I wrote in my motion that I'd like you to rule on. Because I believe under Arizona ARS, the prosecution shall be dismissed if the finding of this complaint is not sufficient.
The complaint which I have in front of me is sufficient as the law.
Okay, so can you tell me where there's evidence of jurisdiction on this complaint?
Again, we're not here to establish a timeline.
Well, you're telling me it is sufficient, correct?
I'm
So,
ruling as a matter of law, it's sufficient document.
okay, so I'm trying to figure out where on this, because again, I'm trying to understand the nature and cause of the charges against me. I don't see where there's evidence of jurisdiction on this. I don't see.
If the state is unable to produce that evidence at the trial, it will go to trial.
What's that?
And if the state is unable to produce that evidence at the trial, it will go to trial.
So are you telling me that I may be required to enter a plea to something that might not be sufficient?
No, you're not required to enter a plea. The plea has been entered for you already.
So I object to that. Why is the plea been entered for me? Is the court, are you representing me?
Again, I'm not going to enter into a dialogue with the judge.
You're not entering in a dialogue about how a plea has been entered for me?
If you need to get legal advice, you can seek legal advice.
Is that required?
No?
So again, is this a court on record?
Yes.
Okay, so I'd just like to object that I've not entered a plea, and the court is entering a plea for me. I'm trying to enter a plea. I'm trying to understand the charges against me, so I can enter a plea. So, again, on this ticket, is there facts showing that the alleged statute violated applies to the defendant?
Again, I'm not going to enter a dialogue with the judge.
Has there been facts showing there's an injured party on this ticket?
Again, I'm not going to enter a dialogue with the judge.
Has there been facts showing there's loss or damage on this ticket?
Again, I'm not going to enter a dialogue.
Okay, so it's your position that this is a valid complaint?
That's the judgment of the court.
Okay, can the plaintiff certify this complaint under oath?
We should do that at the time.
So, according to ARS 22-311, complaint needs to be certified under oath or commenced under oath in order for it to be a valid notice, complaint, citation, whatever the correct term is. So, if it's not certified, and according to ARS 22-311, it's required to be, how is it a valid complaint for me to enter a plea to?
I'm not going to enter into a dialogue.
So, are you violating 22-311, proceeding with this matter?
The complaint is sufficient on its face.
So I'm asking, according to ARS 22-311, the law requires that the prosecutor commence this under oath before it is a valid citation, complaint, notice, charging instrument.
Prosecutor can't do that at the time of trial. You bring that issue up.
All right, so I'd like to object to that. On the record, the prosecutor has not certified this complaint under oath, and the judge is proceeding to accept it. So do you want me to continue going through the motion? Or,
Why don't you present your oral argument, just your statements as to why this case should be dismissed today rather than going to trial?
So, in both of these motions, I've challenged jurisdiction, and there's numerous Supreme Court rulings. I can submit them to the bench. A 4-page document, exhaustive Supreme Court citations stating that jurisdiction must be proven once challenged before any procedure or proceedings. Again, in both these motions, it's been asked where proof or evidence of jurisdiction is on this Arizona traffic ticket and complaint. Supreme Court states that this must be proven before any further actions. So before we go into that, I'm just curious, are you required to obey the rulings of the Supreme Court?
Again, sir, I'm not going to enter into question with you today. If you wish to continue making statements, and we'll go on with this hearing.
I don't believe I'm making statements. I'm asking questions.
But we're not going to ask questions. We're going to make statements. We're doing it all right.
Okay. So there's my statement. Then the Supreme Court requires jurisdiction must be proven. I'd like the prosecution to prove jurisdiction so that we can proceed.
Anything else?
There's lots actually. Both motions discuss the requirement for corpus delicti. The state's already told me that there's no victim and that on this ticket there's been no response to my questions regarding evidence of damages or injury or loss. So corpus delicti is required in criminal cases in order to make it a valid case. So in my motion I'm asking if there is evidence of corpus delicti, can the prosecution please present it so that I can knowingly and consciously enter a plea?
Anything else?
Yeah, on the motion dated on July 19th, point 5 on page 4, it requires subject matter jurisdiction, or I discussed subject matter jurisdiction. Without the filing of a formal verified complaint, when the statutory requirement is not waived as an instant matter, the court lacks subject matter jurisdiction over this case. It is black letter law that the filing of a complaint gives the court subject matter to hear the case brought before it. And the rest of the page is exhaustive Supreme Court citations requiring evidence of jurisdiction to be presented on a verified complaint in order for the court to proceed. As stated in the beginning of all of my motions, I'm not granting voluntary jurisdiction to this court, and I'm here challenging jurisdiction and applicability of the code, and both of these motions are to strike and dismiss this ticket for lack of jurisdiction and lack of applicability of the code presented on this traffic ticket and complaint. I'd like the prosecution to please present that. That way I can knowingly and willfully enter a plea based on knowing all the information for my Sixth Amendment rights. And under Rule 13 of the Arizona Rules of Criminal Procedure, let's see. Plaintiff is not alleged in the citation any of these things. Let's see, I think. I'm sorry, I'm a little flustered. Again, I'm not trained in this. Okay, I'm sorry. Pursuant to the Rules of Criminal Procedure 2.3a, the complaint must state all of these essential facts. And if it's not there, the court is required. I think the legal word specifically is shall dismiss, meaning there's not another option. It must be dismissed if the complaint does not have these essential facts. Rule 16.6b states that it shall be dismissed. So those are the main points that I've brought up in motion. I can discuss and counter the prosecution's response if you'd like. That is filed on the motion from response to the plaintiff's response to the defendant's motion to dismiss, filed on July 30th. Specifically, plaintiff is claiming that I did not file motions pursuant to Rule 35A. On page 2 of my response, there is quite a few examples from my motion that specifically conform to Rule 35A. Clearly, the above list is not, quote, unintelligible and failing to provide facts and legal support. Defendant in error requests that this response from the plaintiff be dismissed. Point 2, plaintiff is claiming on their motion that I am seeking a Rule 20 acquittal. In my response, I have never stated anything regarding Rule 20. I'm asking if the plaintiff can point to where on any of my motions I have stated a Rule 20 acquittal. The defendant in error requests that this response from the plaintiff be dismissed. The plaintiff claims that the complaint is sufficient as a matter of law, as discussed in the previous minutes, and then asked and questioned without response. I'm motioning that this in fact is not sufficient as a matter of law. Specifically, I'm challenging jurisdiction, which must be proven on record once challenged. If not, then Rule 16.6b requires that this case be dismissed. Point 4, the plaintiff claims the defendant in error is not claiming sufficiency, but rather not guilty. In my response, I'd like to ask where the plaintiff has seen that I am writing that I am not guilty. In fact, on July 19th, I'd said that I'd like to try and enter a plea as soon as I know and understand the charges against me. I have not once said that I'm not guilty. And in fact, there are 6 specific points on my motion that challenge the sufficiency. I can read those into the record if you like. Clearly, the above list is claiming insufficiency by challenging the sufficiency of the complaint. The defendant in error requests that this response from the plaintiff be dismissed. Point 5, the plaintiff claims defendant in error is seeking the court to weigh evidence prior to evidence being presented. According to facts and legal support and numerous citations on this response and the motions filed by the defendant in error, the court, on motion of the defendant, shall order that the prosecution be dismissed upon finding the indictment, information, and complaint is insufficient as a matter of law. If the plaintiff is stating that the defendant in error must enter a plea to a complaint that may not be sufficient or constitutional as a matter of law before the sufficiency of the complaint can be challenged, clearly this position goes against numerous Supreme Court rulings and facts of law. Citations and case law are omitted in my response as they are exhaustive, self-evident, and a comprehensive list with case extractions would exceed thousands of pages. The defendant in error requests that this response from the plaintiff be dismissed. The rest of my conclusion, I've already said most of it. I believe that's all I have to say right now regarding the motions that I've filed.
So the court does accept the motion as filed. Basic requirements. Over 90% of people who appear in misdemeanor cases in court are not lawyers, not law trained. Law is clear. Everything doesn't have to be down to the very letter in order to find them adequate. So the court does accept all the motions that you have in file. The issue for the court is whether the ticket can be dismissed today. The court rules that it cannot. Motion to dismiss is denied. The complaint is sufficient on its face. Any of the issues raised by the defendant in the case are issues that will be addressed at the trial. Obviously, since they can't prove those things, the defendant will prevail at that time. Next step in the process then is the sub-trial.
Objection. So what in particular on these 2 motions are you denying? Or what particular?
This is denied. The motion for dismissal of the judge is qualified the judge's continuing the case. Judge Blake actually.
Okay. So regarding the motions to dismiss, what in particular are you denying? Because there's several specific and precise points listed. Each one are fatal flaws.
Complaint is sufficient on its face. All those issues that you raised are on the complaint itself.
Are you able, or can the prosecution tell me where those issues are on this ticket? Because again, I've not been able to get it.
I assume they could do that if they wanted to. They could do that, but they don't want to.
So the prosecution does not want to provide evidence.
If they're not here today. I'm just assuming that.
So I believe the prosecution is here today. I spoke with that lady right back there.
Correct. But they're not, they chose not to be here.
Chose not to be at the hearing.
Trial date will be set. If they're not at the trial, the ticket will be dismissed.
So you're I'm just trying to get wrap my head around this. So the motion is, the ticket you're saying is sufficient. We will schedule a jury trial.
No, the scheduled trial before the court is not jury eligible.
Okay, I believe Class 2 misdemeanors are jury eligible.
It's not true.
Interesting. Okay, so I'm objecting to this again. I still do not believe I've entered a valid plea in this case, and I'd like to schedule a pretrial conference with the prosecution.
That was scheduled today.
So she pushed me in here. I'd like to. There's a discovery requirement before a trial, correct? So I'd like to have a pretrial conference with the prosecution in order to go over discovery.
They didn't provide you with discovery today.
All she did was ask me my name, offered me a plea deal, and then pushed me in here.
They didn't provide you with a copy of the police report. Things like that.
They provided me with some of it. Someone emailed me a copy of the police report, but I have lots of other things I've asked them in discovery that still has not been provided. And then I had also discovery to provide to them.
Okay, scheduled pretrial conference. Okay, you have a way to get that information for you out of the computer.
So-
Engel? And wow. You're the first. June 28th of this year.
Come on in. And the judge already saw you and helped you out?
Not really.
Not really? Okay. Did you get a new court date or anything like that?
I'm not sure exactly what the date is. Just give me a second.
Sure.
Get some of my stuff out. So again, what was your name?
Paula?
Paula. And you are the Scottsdale City Prosecutor?
I'm one of the prosecutors, yes.
Okay.
I'm just trying to get your file.
I understand.
What do I do with it? And it's like, right?
Yes.
There it is. Alright, it's at the very bottom. Okay. Alright, so,
So I believe we are going to trial right now. So
Okay.
I've submitted a discovery request. I have a lot of specific questions I'd like from the plaintiff regarding evidence.
okay. Are you tape recording me?
Yes, for my own notes and everything.
Okay.
So I'm allowed to. It's loud. So, and it's that way I can adequately prepare for my defense.
Oh, okay. Okay, so you're asking for a trial, right? Is that right?
Yeah, I believe so. I believe I'm allowed to ask for a jury trial. I need to look up the specifics of that.
No, this does not qualify for a jury trial. Consuming alcohol in public is not a jury trial offense. So we will be setting it to a bench trial. And I'm going to ask that you list your witnesses
Mm-hmm.
on this form here. So here's the form. You list how many witnesses you're calling, how long the trial, the presentation time is going to take you. You list the
Mhm.
people here.
Yeah, there's not going to be enough
Um,
room right there. So just to start, I've got lots of questions I've got to ask for you. I have about a dozen witnesses
Uh-huh.
that
That's okay.
corroborate.
You
I know.
can
So I'll
list
just
them.
I'll mail that to your office later. I actually have it here.
Oh,
I
you're
can
gonna mail it to
I
our
can email
office?
it to you right now if
Okay.
you'd like. I've got about a dozen witnesses corroborating my story,
Okay.
along with the lack of evidence or facts from the prosecution. So I can mail those witnesses. They will either be called here with a subpoena or filing an affidavit because they live out of state.
All right. Sounds great. Okay, I'm going to list my witnesses on this sheet for the court. And it looks like we're just calling an officer.
Mm-hmm. All right, and I already have his statement.
Okay, great. Any of your witnesses need an interpreter?
No.
Okay. I don't have any issues that need to be resolved, so I'm going to mark that. Okay, so this is the trial form. So if you want to fill this out here, with your signature, address, phone number.
I believe you guys already have all of that on file.
Okay.
So I'd like to go over the many things I'm requesting from your office for discovery for this trial.
Did you send that to us?
Yes, and none of it has been answered. This was actually sent to you guys, I think June 30th, and none of it's been answered. They
Okay, I haven't
specifically-
had a chance to take a look at it, so I'm probably not going to be able to discuss it with you right now. But you said you mailed it June 30th?
Let's see. The original one I mailed to you, your office received July 2nd. There's been numerous other iterations of the same thing. Not received much in response. So I'd like to just ask you now if this one witness that your office plans to call can do this. So can that one witness, Officer Bailey, is that who you rely on to prove that I was within the state of Arizona?
That's our witness. We're calling one
Okay.
witness, Officer Bailey.
Okay, and can Officer Bailey prove, that's who you rely on to prove with evidence that I was within the city of Scottsdale?
That would be Officer Bailey.
Okay. Will Officer Bailey be able to prove with evidence, personal first-hand knowledge, that I am subject to the laws, statutes, codes of the state of Arizona?
we're calling only one witness, and that
Okay.
would be Officer Bailey.
Okay, I would like to go through because I have a lot of questions so I can adequately prepare for my trial. So is Officer Bailey, is he going to testify that he filed a valid cause of action providing corpus delicti on this Arizona traffic ticketing complaint?
We only have one witness.
Okay, so I'm just asking you, will Officer Bailey be testifying to these?
Officer Bailey is our only and sole witness.
Correct,
for
so,
now.
uh,
If we have any other witnesses, we will have to let you know.
Correct, so will Officer Bailey be testifying to these specific points? These are elements of the charge, so I'm asking who you rely on to
You can
prove.
interview Officer Bailey. I am not Officer Bailey.
Correct, I know,
I'm-
but you are the
know,
plaintiff bringing this
I know,
witness.
but if you want to ask Officer Bailey questions, you'll have to set up
Well,
an interview with him.
That will be, I
So
probably would, but I'd like to know.
The interview process would be between you and Officer Bailey,
Right.
not myself.
All right, I know, but you're the plaintiff, and I'm asking you who you plan to bring
I'm
to trial.
I'm the prosecutor.
Right, so
I'm
you're
the state.
representing the plaintiff. I believe the plaintiff is the state is the plaintiff, correct?
Okay.
Okay, so Officer Bailey, to confirm, is your witness you plan to bring to show that I was present within the state of Arizona, city of Scottsdale, and the laws, statutes, and codes of the state of Arizona are applicable to me? Is that correct?
That's what we plan on. We plan on proving
Okay.
the charge.
So Officer Bailey will testify to that. Okay.
Officer Bailey's our only witness, and like I said, if you would like to interview him, we can set that
Well,
up.
yes, I would, but right now I'm just asking you which witnesses you plan to prove these specific elements that you're accusing me of. So,
Like I said, we only have one witness, so
I know,
it's just
so
Officer
I'm just
Bailey.
asking you if he will be testifying to these specific elements.
You'd have to ask him.
Well,
set up an
he's
interview
just
with him.
a witness. You guys are bringing the charges against me, so I'm
Yes,
asking you.
but he would be the witness to testify. I can't.
Correct, so I'm asking
I mean, I
you-
can't testify on behalf of Officer Bailey. If
I'm not asking you to testify,
I
Paul.
can't.
I'm just asking you questions who your witnesses with personal first-hand knowledge are that you're going to bring to trial.
And I've answered. I think I've answered that and told you it's going to be Officer Bailey who's going to testify as to proving the charges.
Okay, so
And yes, he has to say that you're in Scottsdale.
So every element of the charge, is that correct?
I have to prove every element beyond a reasonable doubt. That's correct.
Okay. So, is Officer Bailey, he's your witness, who's an expert in the interpretation and application of Arizona law?
I don't know. You'd have to ask Officer Bailey that question. I'm not calling him as an expert witness. I'm calling him as an officer.
So, what evidence do you have that a valid cause of action has been presented to the court?
It's in the police report. You can order a copy of the police
Right,
report.
I have a police report, so I'm asking you specifically where on this police report is there evidence that a valid cause of action has been presented to the court? I can bring up the police report right now if you'd like.
And,
so-
I'm not sure what you're asking me.
I'm asking you on this police report, where is there evidence that there's a valid cause of action?
Well, it looks like Officer Bailey made contact with you. He detected an odor of intoxicating beverage coming from your mouth. He said you had bloodshot and watery eyes. He observed a cup and saw a small amount of brown fluid in the bottom of the cup. He smelled the cup. He smelled that it was alcohol. Let's see. He watched you lift the cup up to your lips, tilt your head back, and drink it. And that you're in Scottsdale. That's it. I mean, it's all in the police report. Everything. I'm reading the police report to you.
Right, I have the police report right here.
Okay.
So specifically on this this alleged valid cause of action, where you're saying it is in here, valid cause of action also has evidence of jurisdiction.
He will say that you were in Scottsdale. Yes.
So there's evidence of jurisdiction on this valid cause of action. Is that correct?
Yes.
Okay. Is there evidence that the code applies to me on this valid cause of action?
Yes, it applies to you.
Okay. So then my question is, what evidence do you plan to present, or what witnesses do you plan to present with personal first-hand knowledge?
Officer Bailey.
Officer Bailey, that
Mhm.
he has evidence that the code applies to me with personal first-hand knowledge? Okay. Where on this allegedly valid cause of action is there evidence of damages, loss, or injury? Can you tell me where that is on this police report?
You're not charged with criminal damage, you're not charged with, assaulting somebody, and I'm not sure what you mean by loss.
Well, according to the rules of criminal procedure, it needs to be corpus delicti. I'm sure you're familiar with that. One of the requirements of corpus delicti is damage, loss, or injury. There's numerous citations I've provided on the motions, copied to your office. So I'm asking you, what evidence do you plan to present to show that
We're
element
gonna
of the case?
call Officer Bailey and he's gonna testify as to what he observed. That's it.
Okay, so then to confirm, Officer Bailey is your only witness with personal first-hand knowledge that the prosecution relies on to support all elements of the alleged crime
Yes.
and valid cause of action.
As of now, if we come up with another witness, we will let you know.
Okay, so he will be presenting evidence with personal first-hand knowledge of jurisdiction, applicability of the code, damages, evidence of a victim, evidence of a valid cause of action, all of that, correct?
The only witness we're calling is Officer Bailey.
Okay, and I'm just...
As of now.
I know,
If
but
we-
you-
if
I'm
we
just...
come up with some other witnesses, we will let
Well, I
you
know,
know.
but,
And if you'd like to schedule an interview with Officer Bailey, I'd be more than happy to arrange that for you.
Yes, let's. I'd like to have that scheduled.
Okay.
But I'm just a little confused here because all you are telling me is that Officer Bailey is your only witness, but I mean you are confirming that he's the witness you plan to call to prove all of these elements of the crime, correct?
Correct.
Okay, so Officer Bailey will.
And the judge needs to know your decision on what you're going to do today. So.
Well, I know I'm still in
Right,
a
but
pretrial
I mean, the
discovery.
judge, you're the last one here, so.
Okay, it
Well, I'm
sounds like
just-
the judge wants you
I'm
to go
telling
in the
what the bailiff
courtroom.
wants done. She needs to know what
Okay,
you
so
want to do. So
just
you-
hold on, I'm a little flustered.
No, I
It
know.
sounds like
Well,
you
I
guys are trying
understand
to
that.
rush me right
I'm the
now.
messenger, so the bailiff needs an answer. So you don't get to dictate how the court
I'm not
proceeds.
trying to dictate. I'm just
Well,
trying.
I'm just telling you they
Oh.
need an answer on what you'd like to do today, whether you need a new
I'm
court date.
just trying to follow
Right,
Rules
but,
15
okay, well then
for
you can
criminal
go in
procedure.
and explain to the court that you need more time, but they're basically saying they need to know because you're the last one here.
I
And so
know.
the judge can't stay here forever.
Neither
So-
can I, so I'm trying to finish our
Okay, well, I'm just
required,
letting you
our
know,
mandated
I'm
pretrial
letting you know
discovery.
the bailiff needs an answer pretty quickly on what you'd like to do today, whether you need a new court date or whether you want to set it to trial.
Well, I'm trying to figure that out with this pretrial
Well,
discovery.
you've been in here for at least 10 minutes already, and you've already spoken to
So,
her before, so I'm just
Are
letting you
you,
know.
I'm just a little confused. It sounds like you're trying to rush me out of
No,
something
no,
that's
I'm
required
telling
by
you
law.
that the bailiff is basically
so,
saying we have to wrap this up.
if you could tell him that I have legal right to pretrial discovery according to Rule 15.1.
Well, yeah, you do, but if they're gonna leave the courtroom, then we're all out of luck, so.
So, can your office provide me with a copy of Officer Bailey's oath of office?
His oath of office?
Mm-hmm. I believe if he's allowed to, if police officers have oath of office.
You're gonna have to request
I have.
that in writing,
I have.
okay?
I've requested
And
it
if
3
you
times.
feel like we have not complied with discovery, you're gonna have to file a motion.
I have.
Okay, well, the judge has to hear the motion.
He just did.
And what did he say?
He said you guys need to present it. And
Okay,
if he
we'll
has-
get a minute entry from him stating that, then we will comply with the court order.
Okay, so you're saying that you need a court order to provide me with discovery?
No, you're telling me that he ordered it today, so we will
Right, I've
receive
asked
a minute
you.
entry from the court, if that's what you're telling me.
Okay. All right, so I think we're pretty much done here. I just wanted to confirm what we've gone over. You've received my discovery request, and that Officer Bailey is your only witness that
For now.
that you plan on
Yeah, and
calling for now.
you're telling me you're gonna send me your witnesses.
Yes, I can
'cause
email
you
it to you right now if you'd like.
have-
Or I can, if you have
It's
a
up to
printer, I can
you.
email it to you and you can print it right here, and then we can file it together.
No, you have our fax number and our information, so
Mm-hmm.
we will receive your witnesses, okay?
Okay.
All right. Okay, well, it's
And-
nice talking to you, and we will see you at your trial. And thank you very much.
Read over this paragraph and then initial in the box and then fill out that bottom portion for me, please.
I'm still a little confused because I'm almost positive that I'm allowed a right to a jury trial. So I'm a little iffy on signing this because it says I'm waiving my rights to a jury trial. So,
Specific charge is not jury eligible.
I just would like to take a few minutes to look this up and confirm that. So, according to Rule 18.1, I have the right to a trial by jury, and I'm not waiving that right. I believe everyone has told me, both the prosecution and the judge, that this is a criminal case. Rule 18.1 is Rules of Criminal Procedure. So, I am requesting a jury trial.
Okay, well, the judge wants it set, for a bench trial.
Okay, but again, I'm not waiving that right.
Did you want to file a motion requesting
Well,
jury trial?
I don't need to file a request. It's Rule 18.1 that I have the right to a jury trial. What's that?
It's not jury eligible.
This is a criminal case. It is jury eligible.
I understand that you're a pro per, and I can't give you legal advice, but this specific charge is not jury eligible.
So this is a criminal case.
You may want to do some research prior to filing motions for expounding criminal law. Do you want to file a motion?
Motion for what? Well, I'm not signing a form saying I'm waiving my right to a jury trial, if that's what you're asking.
Okay. We've been directed to send it to a bench trial. We're not going to send it to a jury trial without the judge's direction.
Okay, so if possible, I'd like maybe the judge to explain how my rights to a jury trial are being overruled.
The judge doesn't explain anything to you. If you want to file a motion, you know welcome to do that.
Well, he's violated, the rule state 18.1 that you have to file a jury trial. So, I mean, I don't see how you guys are not doing that.
The reason why you don't see how is because you're Googling your answers.
No, this is from the Arizona government website. It's right there at Rule 18.1 of criminal procedure.
Just go to have a seat over there.
All right, clear on record, CO 2013-017024. Sir, state your name for the record, please.
My name is Adam Ligner.
Okay.
Who are you?
Sir, we have a motion here by the state to set your case to trial.
Okay,
So
who,
we are
I'm
going
sorry, who,
excuse me,
who am I talking with right now?
I'm Judge Hendricks.
Okay.
We're going to set your case to trial.
A jury trial, correct?
This charge is not eligible for jury.
So, objection,
No, excuse me, sir, you can't talk over me. If you feel you're entitled to a jury trial, you can file a motion, but the court at this point is going to set it to bench trial.
so, objection, according to the 14th Amendment and the 6th Amendment and
This is
Arizona
not the
Rules
time.
of
This
Criminal
is not the
Procedure
time.
18.1,
Sir, if you have a
can you
motion-
please not talk over me?
No, if you have a motion, you can file it. Motions aren't heard without the other party present and prepared to put their argument on the record. So.
Okay,
there's
but
no-
I'm
no,
not,
no, no,
I'm
no,
not
no.
making a motion. I'm trying to ask a question how my constitutional rights and the rules of criminal procedure are being violated right now.
You can file a motion if you feel that's the case. We're not gonna
But-
hear it right now. Right now, it will be set to bench trial, and you can file a motion. The state then
Okay,
gets an
objection,
opportunity to-
how are you setting it to bench
You don't
trial?
object when the court's talking, that's not how it
I
works.
believe that is how objections
not.
work.
You're gonna sign for your trial date. If you have a motion, you can file it. The state will then get an opportunity to respond, and the court will rule. You don't just come in and one party argues their position. That's not how the rules work. Okay? So, sign for your court date, file your motions. Thank you.
What happens if I don't voluntarily waive my rights? and sign that document. Well, I'm not, I'm asking, am I required to waive my rights right now? Am I required to sign that document right now?
If you don't want to, I can put refuse to sign. That's your choice. But
Yes, I'd like to,
Okay,
what
go ahead and
happens,
indicate refuse.
what happens if I refuse to sign this? Am I allowed to refuse to sign this? Or will you have a bailiff arrest me?
you will not be arrested. We'll just set the trial. You will be given notice. Nothing's gonna happen if you refuse to sign. We'll just indicate defendant refused to sign.
Okay, yeah, I'm refusing to waive my rights to a jury trial.
This is a copy of the trial date. I can get you a date and sign the bottom.
Do I have to sign this one also?
If you do not wish to sign, that's fine. I can just put refuse to sign. But you were made aware of your court date of September 25th at 8:30 a.m. here in court number 2.
Alright, I'm not voluntarily waiving any of these rights.
Okay, so I'll just put refuse to sign.
Especially when it says this is considered a waiver of your rights. So,
That's fine. That's your copy. You're free to go.